Hello, welcome to my channel. Again, this is Geoffrey Pagdanganan. This is Labor 101A. And for this session, we're going to discuss about the common concepts of labor law. Okay, so we will discuss the following key concepts. Number one is forced resignation, floating status, demotion, constructive dismissal, gross negligence as a ground for dismissal, abuse of authority, also known as oppression, preventive suspension and suspension as a penalty, and lastly, redundancy and retrenchment. So resignation as a general rule, or resignation is really defined as the voluntary act of an employee who finds himself in a situation where he believes that personal reasons cannot be sacrificed in favor of the exigency of the service. And he has no other choice but to disassociate himself from his employment. In other words, forced resignation, there's no such thing as forced resignation. So the rule is that resignation should be voluntary. Okay, voluntary resignation is also known as termination by the employee without just cause. So without any cause whatsoever that the employee may choose to stop being employed with a particular employer. That's under Article 285 of the Labor Code. So a decision to give a graceful exit to an employee rather than to file an action for redress is perfectly within the discretion of an employer this time. This is the definition of forced resignation. Okay? It is not uncommon that an employee is permitted to resign to save face after exposure of a or of malfeasance. The court held that an employee who leaves under such circumstances is considered as having voluntarily resigned. So at the end of the day, what we call as forced resignation is actually still considered under jurisprudence as voluntary resignation, although we call it as forced resignation. Okay. Now, floating status, on the other hand, means an indefinite period of time when one or an employee does not receive any salary or financial benefit provided by law. So when the floating status of an employee lasts more than 6 months, they may be considered as having been illegally dismissed from the service. They are entitled, therefore, to the benefits of separation. That's under the uh, ruling in Agro-Commercial Security Services versus NLRC. Why are security guards the main topic here? Because a floating status usually refers to security guards or persons or employees who are outsourced. So security guards, security personnel, or janitorial services. What else? Let's say drivers in certain cases. What else? Secretaries or messengers. So these people are outsourced and they're usually not regular employees. Okay, and they are let's say assigned to a particular client. Let's say a security guard is assigned to a mall, or a security guard is assigned, let's say, to a factory. So in cases involving security guards, a relief and transfer order itself does not sever the employment relationship between the security guards and their agency. So it doesn't necessarily mean that they are separated or terminated from their employment. Employees have the right to security of tenure, but this does not give them such a vested right to their positions as would deprive the company of its prerogative to change their assignment or transfer them where their services as security guards will be most beneficial to the client. Let's say this particular mall does not need 100 security guards, so they will be transferred to, let's say, another mall or a factory or a bank or another establishment. So that means that these employees, these security guards, are not entitled, or they do not have a vested right with regard to that particular client that they are assigned to. So the same is true with outsourced services. So let's say we are outsourcing services for client A. So it doesn't necessarily mean that that employee will forever be assigned to client A. So the outsourcing company may assign that person to client B or client C. So depending on the needs of the clients. Okay, the employer has the right to transfer or assign its employees from one office or area of operation to another in pursuit of legitimate business interest, provided that there is no demotion in rank or diminution in salary, benefits, and other privileges. And the transfer is not motivated by any discrimination or bad faith or effected as a form of punishment or demotion without sufficient cause. Take note of these requirements. There should be no diminution in in salary, benefits, and privileges, and the transfer should not be motivated by any discrimination, bad faith, or form of punishment or demotion. Let's say transferring, let's say, a security guard from an area of assignment where he will be displaced further from his let's say from his residence. So let's say the security guard employee lives in Antipolo and he will be assigned, let's say, to Cavite, when in fact there is a vacant position or security guard post in the area, let's say, of Marikina or Angono, something like that. So while petitioners may claim that their transfer to Manila will cause added expenses and inconvenience, absent any showing of bad faith or ill motive on the part of the employer, the transfer remains valid. So just the mere inconvenience, as long as the bad faith of the employer cannot be proved, it will be considered as a valid transfer. That's the case of Mohar versus Agro Commercial Security. So let's go to demotion. Demotion is defined as a movement from one position to another involving the issuance of an appointment with diminution in duties, responsibilities, status, or rank, which may or may not involve reduction in salary. So take note that in this definition, there's a distinction between demotion and reassignment. Where reassignment here is the movement of an employee from one organizational unit to another in the same department or agency and does not require the issuance of an appointment. Okay, the motion requires the issuance of an appointment as distinguished from a reassignment. Now, why is this case? Why does this case involve the Civil Service Commission and an individual? Take note, demotion as a rule. So demotion only takes place in the government service. So uh, in the private sector, so demotion is actually unheard of. You're not supposed to demote an employee. And why is that? Because demotion is also tantamount to constructive dismissal, which is the next concept that I'm supposed to discuss. So as we mentioned earlier, so demotion may happen and it's distinguished from a reassignment, and it usually happens in the government service. Why do we say that it only happens in the public sector and the government service? Because if you demote an employee, that would be tantamount to constructive dismissal. Why? This is the definition now of constructive dismissal. When there is cessation of work because of continued employment is rendered impossible, unreasonable, or unlikely, as when there is a demotion in rank or a diminution in pay, or when a clear discrimination, insensibility, or disdain by an employer becomes unbearable to the employee, leaving the latter with no other option but to quit or to resign from his employment. That is the case of Cosare versus Broadcom Asia Incorporated. Now, based on this definition, if an employee is demoted, that is equivalent to constructive dismissal. So one factor would be demotion in rank. One. The second is diminution in pay. Third is discrimination. Fourth, we have insensibility or disdain by an employer. So one example of insensibility would be, let's say I'm a manager and I have 10 subordinates under me, and we're doing, let's say, a lot of work, and that means I require 10 subordinates in order for the department, let's say, to function properly. And let's say a management decides to reduce the number of employees to half of my subordinates, making it very difficult for me to obtain my objectives or to function properly as a department head. So that may be considered as constructive dismissal depending on the circumstances. So the test of constructive dismissal is whether a reasonable person in the employee's position would have felt compelled to give up his position under the circumstances. It's an act amounting to dismissal, but it is made to appear as if it were not. Okay, so let's say I'm a manager and I work. I need a very high powered laptop for purposes of performing my job. So if management decides, let's say, to take away this laptop which I use, making it very difficult for me to do my work, that could be an equivalent to constructive dismissal. So the management is taking away my tools for my employment. So it's making life miserable for me in the office or in the workplace. So that is equivalent to constructive dismissal. And the law recognizes and resolves this situation in favor of employees in order to protect their rights and interests from the coercive acts of the employer. That is the case of Dimagan versus Duckworks United. So where else can we find constructive dismissal? Or other examples include involuntary resignation. So they were compelled to resign because the situation in the office has become unbearable. So when continued employment is rendered impossible, unreasonable, or unlikely, when a person gets demoted in rank, or when his pay is reduced. So there's diminution in pay. If there is discrimination, disdain, or insensibility by an employer which becomes unbearable to the employee such that it could foreclose any choice by him to forego continued employment. So actually, there's an actual case that I handled with regard to this. So the person, let's say, his rank was he was demoted. So that is equivalent to constructive dismissal. So from I think manager, he was reduced to the level of a supervisor, and then his pay was likewise reduced. That's a diminution in pay. That is also considered as constructive dismissal. So actually, we won in that case, and although what happened was the employer eventually closed, and they are disguising themselves under the name of another company. Now we go to gross negligence. So gross negligence is a want or absence or failure to exercise slight care or diligence, or the entire absence of care. Okay, it evinces a thoughtless disregard of consequences without exerting any effort to avoid them. That is the definition of gross negligence in the case of National Bookstore versus Court of Appeals. Now, we see there that there are requisites before we can consider an employee to have committed gross negligence. First, the negligence must be gross, okay, which is the absence of that diligence required of an ordinary prudent man. So second, there should be habituality. So it cannot just happen once, okay, which implies repeated failure to perform one's duties for a period of time depending on the circumstances. So there's no definite rule, so there's no hard and fast rule with regard to habituality. That's the case of Fuentes versus NLRC. Examples of gross negligence, we have abandonment, which is a clear and deliberate intent to discontinue one's employment without any intention of returning back. So abandonment, the person or the employee left his employment. So the employee did not even notify his supervisor, no letter, no email, no text whatsoever. Second, so the requisites of abandonment are as follows. So there's failure to report for work or absence without a valid or justifiable reason. So he wasn't sick, he did not go on vacation, there was no quarantine, there was no lockdown. So there's a clear intention. Second, the requisite is that there's a clear intention to sever the employer-employee relation. Okay, so we have here a jurisprudence or a ruling of the court in cases where the employee immediately filed a complaint for illegal dismissal. It negates the theory of abandonment. So we cannot say, let's say we're the employer, we cannot say that this employee has abandoned his job when in fact he filed an illegal dismissal case before the NLRC. Okay, so except when the exception is if when there is no genuine complaint, such as when it is used as a leverage against the employer. So let's say, for example, the employee just went ahead or jumped the gun and just filed illegal dismissal. Okay, so he preempted the acts of the employer. So the employer, instead of notifying the employee that he has abandoned his work and he is deemed terminated from his employment, the employee went ahead and filed a case against the employer for illegal dismissal. When in fact, based on the circumstances, it is clear that the intent of the employee is to abandon his job. So that's one of the exceptions. Okay. Another example of gross negligence is habitual tardiness and absenteeism. So generally a form of neglect of duty. These two offenses or infractions, the unjustified absences of a union president for a number of months is a valid cause for dismissal. This is in the case of Kando versus NLRC. Now we go to the next concept, which is abuse of authority. So there's actually no definition for abuse of authority. So we have oppression under the existing jurisprudence. So oppression is an administrative offense penalized under the Uniform Rules on Administrative Cases in the Civil Service. So we take our definition from Civil Service Rules. So this is the definition given under jurisprudence. Okay. All right. So there's grave abuse of authority. Okay, which is a misdemeanor committed by a public officer who, under color of his office wrongfully inflicts upon any person any bodily harm or imprisonment or other injury. Take note of the elements: wrongfully inflict upon another person any bodily harm, imprisonment, or other injury is an act of cruelty, severity, or excessive use of authority. To be held administratively liable for oppression or grave abuse of authority, there must be substantial evidence presented proving the complainant's allegation. So this cannot just be alleged; it should be proved with substantial evidence. Now we go to preventive suspension and suspension. So preventive suspension finds its basis in the implementing rules of the labor code under section 8. The employer may place the worker concerned under preventive suspension if his continued employment poses a serious and imminent threat to the life or property of the employer or his co-workers. Take note, these are the grounds for preventive suspensions. Absent any serious and imminent threat to the life or property of the employer or his co-workers, preventive suspension should not be imposed. Under section 9, now we find the maximum period for preventive suspension, which is 30 days. So employer shall thereafter reinstate the worker in his former or in a substantially equivalent position, or the employer may extend the period of suspension provided that during the period of extension, he pays the wages and other benefits due to the worker. So we find in this provision that the employer, during preventive suspension of the employee, may withhold the payment of his salaries. Okay, so he may not enjoy salaries or other benefits during the period of his preventive suspension. So basically, that is based on the theory that if he continues his employment with the employer, there will be serious and imminent threat to the life or property of the employer or his co-workers. So that is different from suspension as a penalty. So in our handbook, you find that there's suspension as a penalty. So it may be let's say, suspension for a period of 1 day, 3 days, 5 days, or 1 week, or 1 month. So it is different from preventive suspension in a sense that you need not comply with the grounds earlier mentioned. And here in suspension, as a penalty, there's already administrative due process. So the employee was already able to present his evidence, and the employer was able to present evidence, and then the committee who is assigned to evaluate the case has already imposed the penalty of suspension. So that is not the same as preventive suspension, wherein there is still a pending investigation going on with regard to the infraction committed by the employee. Okay, so preventive suspension is imposed and when the continued presence of the errant employee poses a serious threat to the employer, its employees and client while undergoing investigation for serious offenses. So in the case of Woodridge School versus Benito, the court stated that while the employer may place the worker concerned under preventive suspension, it can do so only if the latter's continued employment poses a serious and imminent threat to the life or property of the employer or his co-worker. So as distinguished from suspension as a penalty, preventive suspension is not a penalty and it does not by itself signify that the company has adjudged or decided that the employee is guilty of the charge or the offense charged against him or her. Okay, so I mentioned this earlier. So the employee placed under preventive suspension is not entitled to payment of wages. This rule presupposes that the suspension, of course, is valid. If the suspension is invalid or illegal, the employee shall be entitled to payment of wages during the entire period of illegal suspension. So if you extend the period of preventive suspension beyond the 30-day limit, then the employee shall be entitled to wages and other benefits. How about redundancy and retrenchment? Redundancy exists where the services of an employer of an employee are in excess of what is reasonably demandable by the actual requirements of the enterprise. So the position is superfluous that may be due to overhiring. So there's excess in employees, decrease in output, or drop in market demand for a product line. Okay, that's the case of Dusit Hotel versus Nuwaring. What are the requirements or requisites before we can consider that an employee may be dismissed or terminated based on redundancy? First, there must be good faith in establishing the redundant position. Second, there is no other option available to the employer except to terminate the redundant employees. That means there was already an attempt to try to transfer him to another department or to another unit, and yet there is no other option available to the employer. Third, that there be written notice served on both the affected employees and the Department of Labor. So the DOLE should be informed at least 1 month prior to the intended date of termination. Fourth, the separation pay is paid to the affected employees in such amount equivalent to at least 1 month pay or at least 1 month pay for every year of service, whichever is higher. So a fraction of that of at least 6 months shall be considered as 1 whole year. Okay, in case the CBA or company policy provides for a higher separation pay, the same must be followed instead of the one provided in Article 297. Okay, the last requirement is that there be a fair and reasonable criteria in ascertaining that what positions are to be declared redundant and accordingly abolished. Okay, moving on. I guess that's my last slide. So thank you for watching, and I hope you subscribe and like this video. Thank you.